course, our colleagues who joined us online. Good afternoon for those who are in Tokyo, and we start. So this event will be recorded, and so it will take around maybe 40 minutes for an active session, and then we will get to questions and answers section. For those who doesn't know, my name is Georgy Daneliya. I'm a counsel and the head of Japanese desk at CMS Russia. And today I'm here with my colleague Igor Sokolov, who is our main and leading litigation expert at our firm. And the topic of our presentation, of our seminar, is commercial contracts, practical tips from litigation lawyer. So we continue with this seminar. We continue a series of seminars devoted to commercial contracts and to other aspects of Russian law. And today we are going to discuss not commercial contracts as such, but from the angle of litigation and arbitration. And these aspects are not so obvious sometimes, and often clients or their counterparties overlook these aspects when they are deciding to do the contract, and this may lead to some negative consequences in the future if something goes wrong. And as we know, in our current environment, I mean pandemics and all the related issues, it is more or less often that implementation of contracts goes wrong, and some force majeure events happen, etc., etc. So we are starting from the basics, which go to the first slide. We will start from the basics and devote some time to dispute resolution clauses, to governing law and prevailing language. Those aspects are very closely interconnected, so the order is not so important. We will discuss them in general, and then we will move forward to drafting and performing contracts from the litigation point of view and other practical tips and risks. And of course, we always encourage all our participants, for those who are offline and those who are online, to participate in the discussion, and please feel free to ask questions at any time. And for those who are online, you may use chat and ask your questions in the chat, so we will then repeat them and try to respond. So let's maybe start, and I will give a short word to Igor.
Thanks, Georgy. Thanks. Well, hello everyone. Thanks for attending. Special hello goes to those braves who are attending in person, and well, those who are attending online. As Georgy said, the event will be recorded, so you will get a recording after that. Slides also will be shared, and if you have questions, please ask them in the chat box. We will do our best to respond to these questions as they appear, but well, if we have no time, we will leave them to Q&A session. To those who are sitting with us in this room, again, please do not hesitate to interrupt us just by raising hands if you have any questions, again, as we go.
So, yes, lecture is not interesting for anyone. Like discussions, much better. So, important basics. Let's come to dispute resolution options first. And when we are speaking about contracts, in this seminar, we will mean commercial contracts like supply agreements, distributorship contracts, services agreements, etc., which are usually concluded between a foreign entity, for example, a Japanese company, and the Russian entity, or between two Russian entities, for example, a Russian subsidiary of a Japanese company and its Russian counterpart. So we will skip corporate agreements and this type of special agreements for the purposes of this seminar, but of course we can discuss them as well. And when we're speaking about contracts, commercial contracts, it is often not a single contract, for example, a single offshore supply contract. But sometimes if, for example, some complicated equipment is delivered, some services are also attributed to this kind of contract. And there is an offshore part, which is the main supply itself, and it can be also dealt with an onshore part performed, for example, by a Russian company, for example, warranty services, servicing of the equipment, installation, out of warranty servicing, and other types of arrangements can be possible. So, and this means that sometimes a transaction or a project involves or requires conclusion of not a single contract but several contracts, and it can be up to 5 or 6 if we're talking about some complicated cases. And all these questions which we will discuss today later, they must be synchronized between those contracts, and different arrangements should be taken into consideration. So it's not, of course, possible to discuss all the specifics in this presentation, but we will try to pay some attention to this as well. So dispute resolution. There are several standard options for dispute resolution clauses, and of course the largest contracts between onshore and between foreign companies, between Japanese company and Russian company, usually has arbitration clause, and usually especially foreign companies insist that disputes are resolved in international arbitration. And this is, of course, a very prudent and good approach. There are a lot of reputable arbitration forums for the resolution of disputes. Those are, of course, International Chamber of Commerce in London, for example. Those are Singapore International Arbitration Center, Hong Kong Arbitration, Japan Commercial Arbitration Association, although Japanese arbitration is kind of rare option. In practice, we do not see it a lot in contracts. There are some pluses and minuses of this option. Of course, international arbitration is rather expensive and time-consuming, which is in most cases good when we are speaking about relations between Japanese companies and Russian companies. All of us know that there are different approaches and attitude to dispute resolution between Japanese companies and Russian companies, and when we are talking about contract and some breach of contract by some party, of course, usually a Japanese company tends to negotiate until the last effort, to do all efforts to negotiate the issue and to resolve it amicably, which is a very good approach. And on the contrary, Russian counterparties often consider it normal to go to arbitration or to go to litigation and resolve the dispute in court. In this regard, resorting to international arbitration, which is expensive and time-consuming, may help to prevent those small disputes and help to force Russian counterparty to resolve dispute amicably, because resorting to arbitration requires a lot of efforts and costs. So obviously, awards of international arbitration require enforcement in Russia through Russian courts, but this is kind of standard procedure. It of course has a lot of peculiarities and could be some drawbacks. Igor maybe will say more about that, but it's more or less standard, and usually awards are enforced in Russia without too many issues. Of course, international arbitration is more or less predictable and confidential, and we can say that depending on the choice of arbiters, it can the level of consideration of the dispute can be rather high, and you may rely on the quite predictable outcome of the arbitration, which of course helps. In general, usually we recommend that international arbitration is a suitable option for large-scale and complex disputes between foreign and Russian entities with a value over $5 million. But that is, of course, a very approximate figure, and it's not some strict requirement.
Just one fun fact about confidentiality of arbitration. Well, it's generally accepted that arbitration is confidential, be it foreign arbitration or domestic arbitration in Russia. But when the winning party that obtained an award in international arbitration comes to the Russian court for enforcement, the proceedings in Russian courts are generally public. So a funny thing that may happen is when the Russian court gives recognition to a foreign award, it would publish the whole text or the resolutive part of the award in its decision, thereby making it public. So just please keep this fact in mind. So before you start enforcement in Russia, consider if it's possible, for example, to close the proceedings, make them confidential in the Russian state court for this and that reason, like, I don't know, storing a commercial secret. Thank you.
So let's move further to the next option, is a Russian domestic arbitration, kind of similar to international arbitration, and also is more recommended in cases when the Russian law is a governing law to the contract, and it also recommended for cases when, for example, two Russian entities are parties to the contract, and otherwise it's more or less the same. Of course, costs are usually lower than in international arbitration forums, and proceedings are relatively fast. Not very fast, maybe depend on the case. So usually we recommend this option to for medium-scale disputes between Russian entities or between foreign and Russian entities if the Russian law is governing. And the approximate value of such dispute is between like $1 and $5 million US, but again, those are not strict figures. First, mentioning at least two forums of Russian domestic arbitration. So it's International Commercial Arbitration Court and the Chamber of Commerce, and also Russian Arbitration Association. So if Igor does not have anything to say,
no,
we will
not now.
Not now. So the next resolution option is Russian commercial courts. It is very often that those courts are named arbitration in Russian language, and unfortunately we see a lot that during translation they are translated as arbitration courts, which is very misleading for foreigners and for those people who are not very well acquainted with the Russian court system, because it is not arbitration. Those are courts of law, those are state courts specialized on commercial disputes. So it's not arbitration. That is very important to keep in mind, and that is why usually we translate them into English as commercial, and sometimes in bracket give this transliteration from Kyrillics arbitration courts. Proceedings there are quite fast, more or less. Usually takes 6 or 8 months to get the binding decision, but of course in our current environment related to pandemic, sometimes it takes much longer. Of course, this kind of dispute resolution is litigation. It's not expensive. The maximum cost fee is around like $2,600 US, which also raises the point that the Russian counterparty may try to resolve any dispute or disagreement related to potential to alleged breach of the agreement in the court without making too much efforts in negotiations, or without looking for compromise between the parties. So that's why Russian companies often prefer this option, and this option is very popular and very common for dispute resolution among Russian companies. Of course, worth mentioning to say that currently the courts are overloaded with work, so you should not really rely that the judge will have enough time to deal with, to analyze in details your complicated case. Also, those courts can be, let's say, administratively influenced. We will not
discuss in
detail here. And of course, we usually still recommend resorting to Russian commercial courts for smaller disputes, especially if you think that in the future you may be a party who will file the claim. So you will be the claimant. Next option are foreign courts. This is a kind of dangerous option, actually, because Russia has very few bilateral treaties between itself and other companies. For example, there is no such treaty with Japan, and often decisions of foreign courts may not be enforced in Russia. It's sometimes very unpractical option. And in our practice, we sometimes see cases when there is a clause in a contract between the Japanese entity and the Russian entity with a dispute resolution in the Tokyo District Court, for example, in Japan. This is very dangerous because the decision of Tokyo District Court, it is very hard or maybe impossible to enforce it in Russia. And vice versa, of course, Russian court decision almost impossible to enforce in Japan, which can be good sometimes, can be not. It depends on your tactics. This should be this kind of option should be used with caution. And also there are some alternative dispute resolution methods, such as mediation, but they are not popular in Russia. We will discuss them here in detail. Next slide, we come to choice of law. This is very, very closely connected to the dispute resolution clause, of course. And generally, this is a very basic advice, but in practice it can be much more complicated. Generally, for international arbitration, we suggest using English law or New York law as a governing law. And of course, if the contract is governed by English law or New York law, we suggest using international arbitration as a dispute resolution option. For Russian arbitration, it's Russian law. Otherwise, of course, using foreign law is possible, but it will increase costs and time for dispute resolution. And for Russian commercial courts, Russian law should be used as governing. Of course, otherwise, the outcome of dispute can be unpredictable, and of course, it will take much longer to get a decision. So, of course, one should decide which law suits the contract better, and then choose appropriate arbitration form. It's very, very interconnected.
Maybe one small comment on the application of foreign laws by Russian courts. Though, as Georgy rightfully said, that it is an option, and the Russian court may apply foreign law. We should keep in mind that if during application of foreign law, Russian courts come into puzzle concerning application, meaning that, for example, we have two conflicting expert opinions. One says that, well, this situation should be decided in this way, and the other way, and the other opinion says that the decision should be like completely different. The Russian court coming into a puzzle would have to apply Russian law.
Yes, and also sometimes the issue appears whether the foreign law may be a governing law for in a contract between two Russian entities. There are two different positions. In my personal opinion, it can be a contract between two Russian entities may be governed by foreign law, but this is completely impracticable because all imperative provisions of Russian law will apply to those parties, which means that still all imperative provisions of the civil code of the Russian Federation, for example, will apply to the contract, and the contract will still have to be fully compliant with the Russian law, which is actually usually our advice anyway for contracts governed by foreign law as well. If it violates or if it's not in compliance with Russian law, which this may potentially bring some negative effect at a later stage during, for example, the enforcement of the international arbitration law. So, moving next. Yes, and also speaking about the choice of law, this issue becomes much more complicated in case we have several interconnected contracts. Of course, if it is only one agreement between the Japanese supplier and the Russian buyer, then using English law becomes kind of standard. Usually we see such kind of contracts, and we also draft English law governed contracts by ourselves with the help of our English qualified lawyers. But in case there are a lot of contracts and the onshore part between the subsidiary of the Japanese company and the Russian counterparty, in this case, of course, contracts may have different laws as governing, and we need to synchronize them better. Prevailing language. More or less simple advice is to stick to make the language of the governing law prevailing to the contract. So if the English law is a governing law, then make English language prevailing, and this is also interconnected with the dispute resolution. If we have international arbitration, of course, obviously English language should be prevailing language, or in Japanese, for example, as well. If the dispute will be resolved in Russia with Russian arbitration institution or with Russian commercial courts, usually Russian language should be prevailing one. Otherwise, we may have kind of war of translation in the court, which sometimes is leads to very stupid situations when we have two translations which are contradict themselves, like they just one says no, another says yes, and the judge says that he or she does not have enough knowledge to understand the English language, and then the decision can be made with any interpretation. So better to avoid such situation. Also, the standard is to make bilingual contracts between Russian and foreign entity. It is not obligatory, but it's very practical because the contract may be also, there may be a need to present the contract to Russian authorities, for example, customs authorities or to tax authorities in the future, and having a bilingual contract helps to avoid the necessity to prepare authorized translation in the future. So I think those were basics, and now I will give the word to Igor.
Yes. Maybe anyone has a question, any questions on Georgy's part? Do you mind if I ask you a question concerning?
Yes, sure.
Concerning
not very.
Well, selection of particular law system, be it a Russian law system or foreign law system, is important. But well, did you see examples where parties subject their contracts to international law, like international conventions on trade of goods? Is it like common?
Well, in my experience, I see in most cases that parties tend to exclude the implementation of international trade conventions, yes, to their contracts. But also we see cases when they apply, and those conventions are more or less not similar, but synchronized with the laws of let's say continental law system family. So if we are talking about Russian law, it's more or less same as conventions. Yes, there are peculiarities.
Well, speaking about my experience, international conventions are very rarely applied by Russian courts because they simply don't know how to interpret them. But when it comes to international arbitration, of course, conventions are commonly applied by them. Well, thanks for your part, Georgy. Now it's my turn. I will also pass me a clicker. Pass me a clicker. Thank you. So my part, I will start with making a contract because, well, it's basic thing. If you don't have a contract, nothing to do. Well, first of all, I have to say that Russian law is a civil law system, and we adopted a civil law approach to contracts. So contract is made under Russian law when all material conditions are agreed. So the common law issues like how we call it, I forgot the word, sorry.
You mean a different concept?
Yeah, a totally different concept. The consideration is not required under Russian law. But the different thing, the material conditions are required. Material conditions, well, first of all, any contract must have its subject matter. So something, some performance which one party must provide to another party. This is why Russian law generally does not recognize abstract contract, where subject matter, like both parties are obliging themselves to be good, so to say, they are not enforceable under Russian law. So all kinds of letters of intent, they are like outside of Russian law. Then the second material condition is mandatory conditions prescribed by the law. Again, this is Russian law. For some types of contracts, the law prescribes that these or that condition is material, and therefore it should be put in the contract. And finally, the most tricky thing is condition designated as material by the parties in the contract writing. And this is actually a very dangerous issue because sometimes parties tend to put into the contract some very irrelevant things and designate them as material conditions. On the stage of performance, this may lead to an early conflict or potentiality for opening a litigation. If one of the parties makes a mistake and like violates this condition which the parties described as material, though in reality, for the purposes of the contract, this condition is not material. The second point is form of the contract. Russian law recognizes the written form of the contract, and of course, as technology goes on, new forms of the contract, electronic form of the contract, for example, or signing a contract by email, they started to be used and practiced more and more. But still, Russian courts prefer written paper contracts with written wet signature on it. And well, to the best of my experience and knowledge, sometimes Japanese parts, Japanese entities, they place their seals on the contract, but they omit the signature, this hand signature. This is really important. Please do not forget that the main executive person of the company or any other representative of the company should put its hand signature on the paper.
Let me just interrupt.
Yes.
There is a kind of practice, especially among American companies, that appendixes to the contract are not signed, and sometimes those contain really important terms and conditions of the contract. And this practice also should be avoided. If there are appendixes to the contract, they should be signed as well. Those are obvious things for Russian practice, but sometimes overlooked by foreign companies.
Yes, and well, if the written form of the contract is not complied with, as a general rule, you may not, in case of conflict, you may not rely on witness evidence, so you may not call a witness and ask him to confirm that the contract has been made on this or that conditions. And for some specific contracts, it will be invalidated. And well, to the best of my recollection, until the very recent times, the international contracts in Russia were mandatory to be made in writing. But now that's not the case.
That's general.
Yeah. That's general custom, so to say. Representations. Quite a recent introduction into Russian law, because they were taken from common law contracts, common law systems. In my experience, sometimes the parties tend to put into representations some very abstract and irrelevant things that may prove to be wrong, actually. We should keep in mind that now such wrong factual statements, such wrong representations, they may be punishable. They may be punishable even if they, at the first glance, do not relate to subject matter of the contract, but still have some relevance to the substance of the contract. Even if the party made the representations as an innocent mistake, such party still may be punished for that. The other party may ask for damages. The other party may ask for unilateral rescission of the contract and contractual penalties. So please just keep in mind that you should not put false or wrong representations into the contract. That may be very important. General rules of interpretation of contract by Russian courts and Russian judges are quite similar to those who are adopted in all civil law countries. So first of all, the judge should read the contract and understand what's being said there. This reading should be made in accordance and in integrity with Russian civil law principles and provisions. What does it mean on practice? Even if you have a lovely foreign law contract and you give it to a very good translator who translates it into Russian, and you would sign it, the judge, when reading this contract, would still apply its own knowledge of Russian law principles. This is why you cannot practically guarantee that the Russian law would not be applied to such contract, even if this contract is, for example, subjected to a foreign law. Literal interpretation is the most common interpretation of contract by Russian judges. Again, I read the contract, I see it, and I understand it as it is. The interpretation may not give any room for abuse of rights by one party over another, and the interpretation should take into account the purpose of the contract and the purpose of legal regulation of such contract. This is how the situation should be in ideal world. Now we will turn to, well, actually, a few words on lack of clarity before I will turn to reality. If the contract is not clear for a Russian judge, it would interpret it against the party who suggested this or that rule of the contract, and a professional party, for example, banks, insurers, lessors, and so on, are always in danger, because the interpretation would be made against such professional party in favor of non-professional party. Sad reality. As Georgy rightfully said, Russian courts are overloaded with work. Not even now, but they always have been overloaded with work. What you see on this slide is the schedule of the Commercial Court of Moscow, which is the first instance court, and probably that's the most popular court in Russia, because Moscow is the center of Russian economy. Today is the 20th of January, and if you see today, the Commercial Court of Moscow would hear 3,098 cases, which means that an average judge would hear approximately 30 cases per day, giving about 15 minutes for each case. So in 15 minutes, you would have to fit 2 presentations of cases by each party, claimant and defendant, and review of documents of this case. Just please keep this in mind. And as Georgy said, the first recommendation would be consider arbitration for complex contracts, and do not go to Russian state courts unless you have a very straightforward and short dispute with some very small amounts of evidence in place. A contract for Russian courts should be simple, clear, and straightforward. And the main idea I would like to communicate to you that, well, ideal contract, trying to draft an ideal contract is probably a myth. So when you make contracts for a Russian court, just please make it as simple as possible and as straightforward as possible, just to make your pain in the future less when it comes to a dispute.
Actually, maybe any contract should be clear and straightforward, but whether it can be simple or not, that's another question. Of course, complicated deals, they are not so simple and straightforward. Involve a lot of arrangements.
Exactly. But in Russian court, in 15 minutes, you will just not have enough time to explain anything to a Russian judge.
Or your 100-page contract.
Yeah, with your 100-page contract. What should be avoided in contractual drafting from perspectives of a litigation lawyer? Please avoid giving different names to some single items, like calling it one document in the same contract, a purchase order, a request of purchase application. This is an actual example I took from the contract I have to litigate right now over. Multiple annexes, protocols of differences, which is in Russian, protokol разногласий.
Very dangerous.
Yes, very dangerous, and the main danger is the high risk of internal conflict between different parts of contract and these annexes. And any other unnecessary overcomplication of a contract should also be avoided if you will have to litigate it in the Russian court.
Coming back to those protocols of difference, they are still common among Russian companies, and what should be taken into account is that, as Igor told before, a contract in Russia is considered concluded when the parties have reached an agreement on all material provisions. So if 2 parties signed a contract and one of them signed it with protocol of differences, these protocol of differences may contain smaller disagreements which are not material for the purpose of this contract from the legal perspective, which means that a contract can be already deemed concluded, but without the important provisions which were moved to the protocol of difference, which can be kind of risky and unpleasant situation especially for a foreign counterpart.
Yes, the Russian party may claim that any condition that was included in the protocol of differences is material condition of the contract, and therefore, if another party fails to perform in accordance with protocol of difference, it's violated the material condition of the contract.
Or it may also assert that it's not material, and that's why you will still have a concluded contract with some conditions which can be very important for you for the procedure and for your usual performance. Yes, they will be not agreed by the parties, which will of course lead to problems in the future, some practical issues. For example, related to the acceptance of good under supply contract, and so on and so forth.
Another section for recommendations. Please do follow the contractual procedures, or do not put them in the contract at all, because quite often we see that the parties write a very detailed contract full of miscellaneous contractual procedures for acceptance of goods, for writing miscellaneous claims on quality and so on and so forth, but they do not follow them on practice. In case of a dispute, this may create a very unpleasant situation because the judge would ask you, why didn't you follow this contractual procedures? Because they are written in the contract. And again, you will have to create some explanation for this question. Just keep in mind the judge's mindset. The judge's mindset is that he or she would try to fit any practical situation, any contract in her own understanding, and her understanding is a lawyer's understanding. So I read the contract, I try to fit it into the law. I hear the parties' explanation concerning how they did behave and did not behave. I have to fit these explanations into my reading of the contract and into the law I have to apply. Some obvious risks of over-detailed contracts. Again, estoppel. Estoppel is quite an early adoption of Russian law from English law, from common law, which means that if you, for example, behave in this or that manner, and the other party accepts this behavior and does not make any claims under it, this party would be stopped and barred from making claims based on this behavior of the party, which was accepted. The other risk is that the court may find that the parties, by behaving somehow differently from what is said in the contract, changed the contract by their own actions. So after that, when a party would come to the court and said that, sorry, the other party had violated the contract, the judge would say, well, sorry guys, you have changed the contract by your mutual behavior. And the most painful development in court proceedings is mutual accusation of abuse of rights. So one party says that, well, you are abusing your rights by doing this. The other party says, no, you are abusing your rights. And well, sometimes there is no way out from this situation. And again, this may create an unpredictability in case of a dispute. Well, it seems that we came to an end. Thank you very much for listening, for attention. We're now ready to get down to questions, if any.
So any questions are very, very welcome. Of course, our presentation, we discuss kind of basics. And, actual practice showed that sometimes counterparties tend to conclude a contract without due review of the contract by litigation lawyers, for example, which should not be omitted, of course. And the contract should be also viewed not only as a program or as an agreement between parties from the business perspective, but one should also keep in mind the situation that it may lead in the future to some dispute. Unfortunately, we should also keep this in mind. And in CMS, we help our clients to develop contracts, to review contracts which they already have, to analyze them from whether they comply with the Russian law or other laws, and also to help to synchronize contracts for the same deal, also from the point of view of litigation and arbitration, which, yes, should not be omitted. I think we have a question. Yes, I think we have a question. Could you please say a few words on the recently introduced anti-suit injunctions that may be imposed by Russian courts at request of Russian sanctioned entities? So this question came from online.
Okay. So the question concerns, as I understand, the question concerns anti-suit injunctions that may be imposed by Russian courts at request of Russian sanctioned entity. So, as I understand, the question concerns the recent concept, which was introduced into Russian commercial proceedings, which is, well, again, following the English law tradition, called anti-suit injunctions, because we all know that English courts love to impose anti-suit injunctions in their proceedings, even overseas. Now, the Russian courts have the same right. A party which is subject to foreign sanctions, a Russian party, may ask the Russian court to issue an injunction which would prohibit the foreign contractual party of this Russian entity to initiate and to continue proceedings in foreign jurisdictions, be it a foreign state commercial court or foreign arbitration court. And in this case, the foreign party would be obliged to discontinue such proceedings, and if it wants, it may come to Russian court and open the proceedings there. Of course, the results of these proceedings will be less predictable, comparing to more predictable, yes, for Russian entity. Well, that's one more complication which should be taken into account when you deal with a Russian entity which is under sanctions or which may be under sanctions. There is no ready-made solution for this situation, but just please keep this in mind, that there's a new risk which may appear.
When you are concluding contract with a Russian counterparty, please do some due diligence and to understand at least. But I know that most of foreign companies do such have a procedure to find out whether a Russian company is subject to foreign sanctions, US or European sanctions as well. So just to be sure that this situation could potentially happen on practice.
Yes.
And Igor, do you know any real cases when this new provision was?
Yes, just recently, before the new year, in mid-December, there was a case where the Supreme Court of Russia, for the first time, gave interpretation to this anti-suit injunction and said that, well, the Russian party is not required to prove anything to ask for this injunction. It does not require to prove that it has any difficulties with accessing justice in that jurisdiction. Thank you.
More questions?
Looks like there are no more questions online.
Okay.
I think.
Maybe we should close the online event. We can of course continue the offline portion.
Yes.
So many thanks for all listeners, for all participants, colleagues. We were very glad to welcome you all virtually here at CMS, and we of course plan to continue this series of seminars devoted to other aspects of contracts and to other aspects of Russian law as well. In particular, we are planning some events related to tax issues such as permanent establishment risks, and also some events related to practical aspects of contract drafting and so on. So let's keep in touch. Thank you very much.
Yes. Bye. If you have any questions, just feel free to send them to us by email. Our contact details are in the presentation. Stay in touch. Have a nice day. Goodbye.
So yes, we finish a live translation.